So their agenda is an agenda of fear. This is what they're saying, does if you want a great North Carolina, then make sure people can get a gun easier than they can vote. That's
the right to vote is a right that has been paid for by the blood.
When voting rights are under attack, what do we do?
And we're going to let the government members of the General Assembly know that you were elected by the people to do the work of the people.
I matter to God. Governor, do I matter to you?
I matter to God. Governor, do I matter to you?
Respect! Respect! The constitutional rights of all people!
And so here we stand as young people. It's now our time to take up and pick up where they're letting go.
It is these poor white Southerners who are so often without health care, who are underpaid and need a raise in the minimum wage.
Voters should have the right to vote, and we will fight for that every day. For everybody.
It's our time. It's our time. It's our vote. It's our vote. It's our time. It's our time. It's our vote. It's our vote. It's our time. It's our time. It's our vote. It's our vote. On today, we want to first thank God for the strength and the wisdom to fight this battle against voter suppression. We want to thank all of our lawyers, Penda Hare from Advancements Project and her team, Penda, where are you, who had to leave to go back, but she did our closing argument. We want to thank Kirkland and Ellis, who came to stand alongside this movement and to give so much service. And Michael, where's Michael? He's right behind me to my left. We want to thank the U.S. Department of Justice who are here today. And I want to say this because I want to make a point in a minute. A diverse team of women, men, African American, white, Asian, Jewish, young and old, who came together to help us wage this battle. I want to thank the seniors among us. I tease them like this. Adam Stein, Al McShirley, who've been fighting these battles for a long time, and Irv Joyner in his absence. I want to thank our tremendous NAACP staff. Michelle Law is our executive director, and the team that's here, been organizing, Laura Ashton and John Steen, and our local branch in Winston-Salem, and our other branch members from around the state. And we want to thank every plaintiff, the churches, the pastors, but especially our three lead matriarchs. Three lead matriarchs. I'm a preacher, and I remember it was the matriarchs in the book of Exodus that helped to save the land save the people of the Hebrews. It's Rosanelle Eaton, young age of 94, excuse me. Ms. Mary Perry, I ain't gonna call it, I don't know. She 86 years old. And Ms. Carolyn Q. Coleman, who was a former executive director of the NAACP, who's not here today, but they've been our three lead matriarchs. It was eerie today to hear Tom Farr and an all-white lawyer group, all-white lawyer, and somebody just said male, argue in essence that the federal government should not be involved in state issues. Sound like that's an old states' rights issue. And to argue what people argued in 1896 when they passed Plessy versus Ferguson, let's pass it and see what happens. It was eerie for them to argue in essence that because this law may only affect a few people, in their estimation, which sounds very much like the lawyers in the past who stood by Jim Crow voter suppression, it was eerie to hear them say that they believe it's okay to pass laws that are only passed for discriminatory reasons, laws that have been passed on the basis of lies and fraud, lies about fraud. It was eerie to hear them say, let the law go into effect. And then after they unconstitutionally discriminate against African Americans, Latinos, and other minorities, just simply say, oops, we're sorry, rather than stopping the law in the first place from ever being implemented, because the data is clear that it's going to have a discriminatory impact. This is un-American. We've been down this road before. It was called Jim Crow. And we do not need James Crow Esquire leading us down this road again. Our case, put on by these magnificent lawyers and witnessed by these magnificent plaintiffs, has proven that this law is unequal, this law is discriminatory, this law is intimidating, this law is unnecessary, because we already had signature attestation, and North Carolina had already moved from the bottom 12 in voter participation to the top 12, and there's no evidence of fraud. This law is a deterrence. This law is a discouragement. This law adds burdens to black people and Latinos and poor minorities who have already had to historically carry the burdens throughout this nation and this democracy. This law is dangerous. It's a dangerous form of political retrogression, because it suggests that simply because you have a political majority, you can retrogress, go backwards, with no consequences on the front end. They admit, even the head of the Board of Elections, that there's no fraud. Tom Tillis admitted before the whole nation on MSNBC when questioned that this was not passed because of fraud. They admit that then it was passed on the basis of misinformation and lies. They admit that they passed a reasonable impediment because they knew the first alliteration was unconstitutional. There were emails shown that proved that point. The legislature said that's why they did it. This law, members of the media, was first introduced during the 2013 session while we were remembering Bloody Sunday. Don't forget that, March and April, and the Selma to Montgomery March. This law's final passage came after the Shelby decision nullified Section 5, when they suggested that now that the headache has been removed, and they knew that they would not face preclearance, because if they had to face preclearance, these laws would have not made it through. And the reasonable impediment portion of this law was passed the day after the Charleston massacre. The day after the Charleston massacre, our legislature was passing in our legislature further voter suppression. This law creates two forms of citizenship. If you're in person, you have to have a photo ID. Signature attestation that has worked is not enough. You have to have a photo ID. But if you're an absentee balloter, you don't have to have a photo ID. That's two forms of citizenship. This law says that even if you've been voting like Ms. Rosanelle Eaton for 70 years, Ms. Perry, how long you been voting? 60 years, 65 years. And you voted on presidents and governors and judges. If you don't have a certain form of voter ID, you have to come in, and you can no longer get a regular ballot, you'd have to get a provisional ballot, even though you've already 60, 70 years been a voter. This law abridges the right to vote. This law forced one of our plaintiffs, Ms. Eaton, to need 21 days, 26 days, 10 trips to try to meet the new rules, even though she had voted for more than 70 years and voted during the election of an African American named President Obama, who became president of a country that once regarded blacks people as 3/5 of a person. And today, even in the closing, it was admitted, this law is still worse than South Carolina's law, and South Carolina just removed the Confederate flag. In a democracy, we should be encouraging people to vote. We should want everybody to vote. On this first day of Black History Month, it is strangely poetic that we are here fighting efforts to repeat history rather than create a better future. On this first day of Black History Month, it is strangely poetic that we are in a state now that has made it easier to get and carry a gun than it is to vote. And so we all hear the spirit of Carter G. Woodson, the spirit of Harriet and Harry Moore. We all hear the spirit of Rosa Parks and Fannie Lou Hamer and Martin Luther King and Thurgood Marshall and Swanner, Cheney, and Goodman, and those 4 students that sat down today in Greensboro saying to us, we cannot allow a miseducation about what's going on here. The McCrory, Tillis, Berger, Moore legislature and Tea Party allies are afraid of a new South, a new fusion electorate of blacks, whites, and Latinos. This is why they desire to suppress the vote. They know they cannot make their extreme case in the public square if everybody is voting, and so they choose instead to use their tentative majority power to suppress the vote. We cannot forget this. We must fight as those fought in the past, and we must ultimately win. This is about racial discrimination. It's not about how many people may be discriminated against. It's not about whether one number is off here or there. Our Constitution was not written to protect a few people, but all people. And if one person's constitutional right is violated, that's one person too many. Discrimination is about any amount of, discrimination in any amount is unconstitutional. This is 21st century Jim Crow tactics like we haven't seen since the end of the first Reconstruction. Because it is a combined attack, and the members of the media, you can't separate it out. It's a combined attack. Removing same-day registration. It was greatly used by African Americans. Shortening early voting. Ending straight ticket voting. Ending out-of-precinct voting. Passing in 2010 the worst race-based apartheid-type redistricting that even the United Supreme Court has sent back to the state saying you didn't ask the right questions about race. This is Jim Crow tactics in the 21st century. And now passing the strictest form of photo ID anywhere. A form of photo ID that says the HAVA law, the Federal Help America Vote Act law standards are not even good enough for North Carolina. The NAACP, Ms. Eaton, Ms. Perry, was born in February by whites, blacks, Jews, and Christians. Frederick Douglass was born in February. The ANT4 sat down in February. Dr. King made his first trip to Selma to get ready for the Selma to Montgomery Selma to Montgomery movement in February. And today, with the powerful closing arguments of our lawyers, a fresh fight for justice has been born again in February. And we will not see our efforts aborted. Forward together, not one step back. There are questions from members of the media, for lawyers who are here, for myself.
Mr. Glick, would you come on up, bro? You heard your opponent in court today say that your case is based on intellectual work. What is your response to that?
We frankly and respectfully disagree with that. I think throughout each of the 6 days of trial here,
we came here in this federal court and we put on evidence of the disparities and the disproportionate burdens that this law is going to have. There's any number of evidence that went in unrebutted. The possession rates of IDs here in North Carolina. Even in closing statement today, the state contended that only 94% of African American registered voters had ID and gave the impression that that was somehow okay. I say, what about the 6% that don't have ID? The tens of thousands of individuals in the state that don't have it. The difficulties obtaining ID and the difficulties filling out and going through this reasonable impediment process. We put on evidence on each of those prongs throughout this past week, and other evidence that you didn't hear from the state this week. You did not hear a single piece of evidence, a single instance of voter fraud, of voter impersonation that this law would ostensibly correct. You didn't see a single member of the General Assembly who voted in favor of this law come here and come to defend it. So we think that if there was anyone who didn't come forth this week with evidence, we think it was the state. And we think that they have, in 2.5 years since they passed this law, failed to come forth with evidence about why it was necessary and why it's beneficial and necessary here in North Carolina.
Attorney Glick, it should also be noted, because it's important, the FAR talked about sound bites. See, he wants the media to pick up the sound bite that 94% of African Americans in North Carolina have ID. That's not true. He's talking about registered voters. He's not talking about those who are unregistered. It is true that African Americans are 50 times more likely, 50% times more likely not to have. So they master in sound bites, just like they call this the voter integrity bill and not a voter suppression bill, because they suggested that the system was broken. They'll claim that North Carolinians were for the photo ID because they went out and gave this propaganda that there was all this fraud going on, when in fact under oath, and even before they were under oath on national TV, after they shared the propaganda, they then had to take it back, which is a common tactic of extremists. They will say things, long before Trump came around, they will say things that know not true. And then when it's corrected in a footnote or in a side note, but it's not corrected when they first say it.
Miss Eaton, did you say something? Has it been a long week?
She said
No, it's a week last week.
She said she didn't want to have a lot to say. She was tired. What she did say was it's only just begun.
Amen.
Thank you all so much. God bless each one of you. Take care.